Okay, good afternoon, everyone. I think we'll get started. A few will be joining from the waiting room, but I think we'll press on because we only have an hour. So good afternoon. My name is Harj Narulla, and this is a webinar on the topic of climate migration in law and policy. This webinar is part of Doughty Street's ongoing migrant rights seminar series, which is running throughout 2023. And today's session is going to be hosted by Doughty Street's Climate and Environmental Justice Group, which was formed at the end of 2022. So for those of you who are not familiar with our group, it was founded at the end of last year, and we specialize specifically in public interest, climate and environmental litigation, both domestically and internationally. I'll be chairing the webinar today, and I specialize in climate law and litigation. I practice domestically and internationally, and also have research fellowships in climate litigation at the University of Oxford and at the Grantham Research at LSE. I also have a particular interest in this topic because I was previously a refugee lawyer. Earlier in my career, I worked on Manus Island in Papua New Guinea and in Lesbos in Greece. So we're very lucky today to have three wonderful panelists joining us, who I'll now introduce. So the first is Yumna Kamel, who's the founder and the executive director of an organization called Refuge, which is a legal think tank focused on addressing climate migration issues through community engagement, advocacy, and education. Yumna is going to be starting us off and will provide an overview of the topic and walk us through some of the definitional issues that we see in the climate migration area. Our second speaker is Doughty Street's Krishnendu Mukherjee, who's a member both of the immigration team and the climate and environmental justice team at Doughty Street. Krishnendu is an Indian qualified advocate, and he works in South Asia in the fields of immigration, environmental law, and business and human rights in particular. Krishnendu is going to speak to the international context so that we can understand how other countries are dealing with this issue. And our third speaker is Nina Kamp, who's a senior caseworker at Duncan Solicitors, and is a specialist in public law immigration work. And Nina's going to be speaking to the domestic, legal, and political context on climate migration issues. So in terms of our format today, this session will run for an hour, and I will invite each panelist to speak for 10 to 12 minutes. We'll then open up for a Q&A for the remainder of our time. So please put any questions that you would like to put to the panel in the Q&A box and not in the chat. So to get us started, I'll hand over to Yumna. Thank you.
Thanks, Harj, and thank you for inviting me to contribute today. I have been tasked over the next 10 to 12 minutes to introduce what I do, what Earth Refuge hopes to do, and also provide a whistle-stop tour of key themes surrounding and relating to climate migration. So I will do my best to do that in a coherent way. I'll start by speaking about Earth Refuge because I think it leads quite nicely into the key themes. So I founded Earth Refuge in 2020 with my colleague Stephanie Hayder in direct response to the fact that there are no legal protections for people fleeing climate stressors. And what was particularly shocking as someone who's approaching this from the immigration angle is that a person is 3 times more likely to be fleeing climate factors than war or persecution. And although there were a few organizations working in this field, they were mainly focused on the academics of the topic, what constitutes climate migration, and sort of policy recommendations. But there wasn't anyone working on the legal matrix and protections on an international or regional or even a local level. So that is what set Earth Refuge into motion. And just to outline the contrast between now and then, There is a rapidly growing climate migration sector now. It's pretty great, but at the time, just to illustrate this, and I always use this story, but I set my Google alerts to climate migration. And for the first 4 months, all I received was notifications about monarch butterfly migrations, nothing to do with human beings. But then the Biden administration released an executive sort of open call for papers and recommendations on climate migration, and slowly but surely things started to pick up in 2021. So in terms of what we do, we focus predominantly on legal research for live cases that feature elements of climate migration, because both lawyers in the environmental sphere and immigration sphere don't have enough knowledge typically of the other field to sort of move forward with cases that have these nuances. So that is a core element of our work. And the next thing we did was launch a database, a legal database on climate migration cases. So we have a team of lawyers, some of whom are core members of our team and some of whom volunteer on an ad hoc basis to analyze existing cases that feature elements that could relate to climate migration. So obviously climate migration, but also the right to health, insurance, all sorts of other things. They analyze these cases through a climate migration lens, assess the validity of certain arguments, or recommend alternative routes to argument. And the point of this is to form a sort of foundation for future climate migration litigation. And it's a resource that's used by lawyers, by academics, by NGOs to inform themselves about this niche. We also do education. So during the academic year, Stephanie and I teach at a number of law schools, typically in partnership with their clinics, to introduce law students to the concept of climate migration before they actually enter the field, to sort of preempt this specialty so that it isn't novel to them once they've entered the profession. And we also launched last year the world's first international school on climate migration. The second year actually kicked off on Monday. We had 370 applicants from over 70 countries, and they get this 6-week summer intensive course on all things climate migration, legal and otherwise. And the last thing we do is focus on community needs, which I suppose underpins the other two elements. Climate migration, as I'll touch on, manifests very differently in different communities. It gives way to different needs. And so we strongly believe in consulting with affected communities, figuring out what their needs are, and then trying to meet them with legal rights. So we do an assessment of what rights and duties exist in a certain area, and then we draft with those communities a toolkit as a sort of accessible guide to what rights they have and how they can enforce them. And right now we're focusing on women farmers in Marathwada in India who are susceptible to and affected by cyclical drought and temporary working conditions. So that was a very quick plug of Earth Refuge, but I will now launch into the climate migration landscape more generally and some legal considerations before Krishnendu and Nina take over. So in terms of obvious definitions, at Earth Refuge, we prefer to use the term climate migration as opposed to climate displacement, which we sometimes use, and climate refugee, which we never use, for reasons I'll touch on now. Generally speaking, migration does have this, this connotation of being a pull factor. So it relates to the taboo of the economic migrant, people who voluntarily choose to move. But we choose to use it because it provides this umbrella term for the different types of movement that exist. Cross-border, internal displacement, forced displacement, or preemptive movement. Displacement actually relates to forced movement. So either a slow onset or a rapid onset event pushing people to move because where they are is unlivable. And refugee is a well-known legal term. I'm sure that most of the people who have joined us today work in the legal sector, but perhaps not in the refugee sector. So just as a refresher, a very simplified definition of a refugee. So this term is enforced by the Refugee Convention of 1951. In order to be accepted or recognized as a refugee, a person needs to jump through a number of sort of metaphorical hoops. But I have coined this very unofficial two-strike theory when it comes to climate migration. Firstly, in order to become or be recognized as a refugee, someone needs to cross a border. So strike one is the fact that with the data that we have, it seems that most people who are fleeing climate factors flee internally. So they're remaining within the same border, but they're perhaps moving from a rural area to a city or cross-country. So that's strike one. Strike two is that in order to be recognized as a refugee, a person needs to show that they are fleeing a likely threat of persecution. So they have a well-founded fear of persecution. And persecution is defined as a targeted threat of danger against that individual on the basis of who they are. And so strike two is that it's very difficult to paint climate factors as a form of persecution specific to an individual on the basis of who they are. There are some ways in which cases can slip through the cracks of this definition, but generally speaking, it takes a bit too much bending over backwards for lawyers to use this as a sort of one-stop shop for protection for people fleeing climate stresses. So that's the two strike here I have on the legal definition of a refugee, which I think Nina will be delving into in more depth. Another general set of definitions that I think are quite important when you're looking at the field of climate migration is the difference between climate events and environmental events. This is a gray area. There is a lot of overlap, but generally speaking, and so as not to delve into anything existential, environmental factors are things that are more directly man-made disasters. So that means things like water contamination and oil spills. Climate, on the other hand, is associated with natural disasters. So that means slow and rapid onset events. So that's sort of a basic distinction between the two definitions. And I think the big theme that I would like to touch on is climate justice and what it means. And I urge you to approach this with caution. This is sort of our working definition at Earth Refuge. Obviously, it's a flexible definition, but generally speaking, climate justice is inextricably linked to racial justice, migrant justice, indigenous rights, intergenerational justice, so the rights of young people, but also future generations. And climate justice wouldn't exist without a colonial legacy. So the underpinning theme is that people who are most affected by climate events live in the Southern Hemisphere or are in states that didn't cause these climate events. Most of the corporate activity that exacerbates climate events is happening in the Northern Hemisphere in states with a colonial legacy. And so there is this notion of a polluter pays principle, where the countries that are causing the most pollution should be protecting people in the countries that are merely impacted by this, but haven't really contributed to it. And I think a really stark example is the floods in Pakistan. Pakistan has hardly contributed any emissions, and yet its citizens are immensely affected by the impacts of climate change. In terms of demographic groups that require climate justice on a global level and by proxy are most affected by climate displacement or migration, it is predominantly Black and Brown nations and also communities around the world, existing immigrant communities and women. So what I mean by this is, generally speaking, we see really clear illustrations of climate disasters in so-called developing countries like Bangladesh, or in poorer states, for example, Louisiana in the US. But we also see it in existing immigrant communities or racialized communities in the developed world. And what I mean by that is, for the first time in history, the majority of the world's population is living in cities. And the increase in city life has increased the existence of slums. And so in slums, we see existing immigrant communities, but we also see new immigrant communities sort of maneuvering their ways into these slums. And that means a lack of sanitation, a lack of infrastructure, a lack of access to basic needs. And that means that they're more susceptible to climate events and movement and insecure living conditions, and a sort of more nomadic, an inflicted nomadic lifestyle. Another illustration is the Rohingya, who have fled Myanmar and ended up in Bangladesh in refugee camps. And then those refugee camps are hit by landslides. And so these existing migrant communities need to move once more as a result of climate factors. And the last demographic group that has been identified worldwide, I should say, statistics on climate migration are quite unclear, they're quite new, but from the statistics that we do have, it is clear that women are more vulnerable to climate migration and also to trafficking, both before their journey, during the journey, and after their journey. And that is because of a lack of education, a lack of societal recognition and equality, and also desperation. If you picture women migrating from a rural area who have farming skills and they end up in an urban area, they are more susceptible to trafficking into factory work and the like. So I'll wrap up by saying that climate migration is not novel. The term environmental refugee was used as early as 1985 by Hassan al-Hinawi on behalf of the United Nations Environmental Programme. I would say that where it has been discussed since the 80s, those conversations have always been quite academic, quite theoretical, and always within sort of academic or policy institutions. And it's only recently that we're starting to see activism and practicality on this topic. And that's what we strive to do at Earth Refuge. And I think that a key turning point was the 1990 IPCC report that explicitly referred to migration as a future issue as a result of climate change. So I will stop there. I'll address more things, I think, during the Q&A, but thank you. And I hope that that was helpful.
Thanks so much, Yumna. I think that was a really useful overview of the many and complex issues at play here and the kind of geographical and conceptual breadth of the issues that we have to contend with as lawyers and as advocates. I've got a bunch of questions, but I'll hold off and pass over to Krishnendu, although I think potentially before we hear from you, we might have a short video which is related to some work in the Sundarbans region where Krishnendu's been working for a number of years. So we'll start with that video and then I'll hand over to Krishnendu.
Yeah, thanks, Harj.
তখন আওয়াজটা ঠিক ভাবে একটা আওয়াজ হয়ে থাকে যে মাটির বাড়ি টালির ঘর যদি টালি উড়ে যায় তখন একটু ভয়েসে বাচ্চা নিয়ে কোথায় যাব কোথায় থাকবো এটাই তখন টেনশন আছে আমার একটা ছোট্ট দেওর ছিল ওই দেওরটা আমি ছিলাম যখন ঘরের ভিতরে জলটা ঢুকছে যখন সমস্ত একটা শব্দ হচ্ছে আমার দেওরটা আমাকে ধরে কান্নাকাটি করছে মানে ও যখন আমাকে আঁকড়ে ধরে আমি ওকেও আঁকড়ে ধরে নিয়ে ওই বাড়ি ছেড়ে মানে উপরে বাঁধের উপরে উঠি আর তখন ঝুপঝুপ করে দেখতে দেখতে চাঁদের দেওয়াল পড়ে গিয়ে ঘরটা এমনিতেই বসে গেল
Geeta Maiti lives in the Sundarbans on Masuni Island. She is one of 13 million people who call this delta region home. Straddling the border between India and Bangladesh, these low-lying islands are facing rising sea levels that are 3 times the global average. Several islands have already disappeared, and scientists say Masuni could be next. Farming is the social and economic backbone of Masuni Island. But flooding, erratic rainfall, and increasingly severe cyclones have left 70% of Masuni's agricultural land barren. The need to buy the food they once grew is forcing young men to leave the land their families have farmed for generations and migrate to the cities for work. Ramjan was only 13 years old when he left Masuni. Now he lives and works in this room with 4 other tailors, sewing from 7 a.m. to 11 p.m. every day. Ramjan makes barely enough to support his wife, their 2 young children, and his mother back on Masuni. But most families can't afford to leave. The state government is trying to help. They're supplying bricks to some who have lost their homes. They're subsidizing rice, an effort to ease food insecurity. And they are building 3 new flood shelters that will help when disasters strike. The state government has built several walls, in sections, over the past several decades. Some lasted, some did not. But when Cyclone Isla hit in 2009, everything was destroyed. Officials say that all embankments have been restored, but almost a decade after Isla, the wall where Gita lives is still being built, and the village where Ramjan's family lives has no protection.
मौसनी में अगर एमंगमेंट का अगर काम नहीं हुआ तो मौसनी द्वीप मैंने बाद में जैसा बोलो तो 2-5 साल 10 साल के अंदर मौसनी द्वीप द्वीप नहीं रहेगा.
Shall I start? Oh, okay, right. Thanks, thanks, Harj, and thanks, Yumna. I think the short clip we saw there really illustrates some of the issues that you were talking about, and I wanted to show it because I think it's really important that we hear from the voices of the people who are affected. From my experience of working in South Asia, the situation in the Indian Sundarbans, as shown there, is being replicated in so many parts of South Asia and other parts of the world through land loss, through livelihood loss, through decreasing access to natural resources. If you scrape the surface of what seems to be a localized problem, you quite often find these recurring themes replaying themselves. Heat will be the biggest cause of migration, the biggest killer in South Asia. People losing their traditional horticultural, agricultural livelihoods and moving into the most exploitative of industries. We're already seeing people moving into industries like brick kilns, in working in unbearable temperatures in the northern states of India, or in areas where they are susceptible to occupational diseases. Those who are forced to migrate in the way that's shown in the film because of their dependence on the environment have not only not, as Yumna said, not made any significant contribution to greenhouse gas emissions, but in fact have made significant contributions in showing us how to protect the environment. So for instance, 2 things I would like to say about Sundarbans. Firstly, when I went there for the first time in 2008, as a result of an article in the Independent, which talked about the first climate refugees, where the island of Lohachara disappeared into the Bay of Bengal and displaced 10,000 people. That area wasn't even electrified. There was no mains electricity, simply renewable energy. And having visited there in January, we saw the ways in which the local population are trying to protect the mangroves because it's important on their livelihoods and so on. And so people migrating lose that traditional knowledge, which will help us mitigate and combat global warming. And so the injustice is not only that they're being forced to migrate because of a problem which is, for the most part, not at all of their making, but that these people who have agency, and we all know that it takes a lot of agency to migrate, are not using that agency in their home areas. They're not using it to protect their home areas, to provide resilience to their populations or to adapt. And the international community's response has been poor. Faced with this injustice, they have not supported migration. They're not even supported internal migration. In terms of transnational migration, we see globally the way in which states are pushing back, saying it's not our problem, it's somebody else's problem. And that's going on across the world. And of course, here in the UK, we see how the 1951 Refugee Convention is being all continuously diluted when we're in a situation where many of the people who flee persecution, or increasingly people who flee persecution, the roots of that persecution, those conflicts, can be seen to be related to climate issues. So the best example being Darfur, where there's well recorded evidence to show that the water scarcity caused by global warming is a major cause of the conflicts there. So that agency should be supported. People who migrate should be supported in their attempt to be resilient in their home area through the transfer of resources. And I don't just mean financial resources, but I also mean technological resources. In the Sundarbans, we see people themselves, making up dikes and dams to stop the seawater coming in, which are, not fit for purpose. When the technology exists, Rotterdam has a brilliant wall to protect it from sea level rise. Why should an island in the Sundarbans not have a similar type of technology? So these people should be supported in that, and they should be supported in their just transition. They have a right to develop. They have a right to improve their life and their children's lives, and there has to be a way of supporting that transition, that development, whilst decoupling it from carbon emissions. For those who are forced to migrate because of global warming, there has to be a recognition of the trauma of leaving your home area, possibly never to return. These people have a huge attachment. They don't want to leave, and they have a huge attachment to their land. And there needs to be built into our response an understanding for people who migrate from the rural to the urban, or from the rural to the rural, indeed people who are forced to move from one country to another. Ultimately, in my opinion, the solution to global warming is not just about carbon. It's about a recognition that all human life has equal value, that Mukherjee Island is as important as London for the people who are living there, and that we cannot move forward by building these high walls between ourselves and our global responsibilities. International law has to recognize the uneven responsibilities that Yumna talked about, and supporting those people who are the victims of that systemic discrimination. The Sundarbans Climate Justice Project is something that we formed about 4 years ago now. It's a global partnership between King's College London, Doughty Street Chambers, National University of Political Sciences, and Jindal Law School in India. And we're seeking to put in play a lot of the principles that I think would be necessary in order to try and mitigate global warming. So to erode the divisions between the so-called global north and the global south, and then create an understanding that the needs of people who migrate, or who are forced to migrate, have to be supported in their home area by states, by corporations, and by the international community. Thank you.
Thank you so much, Tulu. That was wonderful. And again, identifying a really broad sweep of issues and challenges for us as a community of barristers and solicitors and partner organisations as well. So our last speaker is Nina, who will bring us back to the domestic context. And she's going to be speaking to these types of issues in England and Wales. So over to you, Nina.
Thank you. Yes. Really fascinating, Yumna and Krishnendu, and of course Harj for doing this. I am going to become very practical in this session, and really look at knowing that we don't have the international protection available, and recognizing, as both Yumna and Krishnendu set out, the importance of this. How can we still offer protection within the current frameworks that we have within the UK, and of course specifically England and Wales? I am looking at both going to look at an alternative to refugee status, which is humanitarian protection, and whether that could offer some protection for climate refugees. And I'm also going to look at the protections available under the European Convention on Human Rights through Article 3, which specifically regarding inhuman and degrading treatment. But before we get to that, I want to quickly look at why, again, the Refugee Convention is not fit for purpose for climate migrants or refugees. I will use climate migrants going forward, Yumna. That, as Yumna set out, the issue is regarding the targeted threat, and specifically that targeted threat of persecution has to do with particular convention reasons, so characteristics set out in the convention, namely race, religion, nationality, membership of a particular social group or political opinion. And that is the cause of, or the reason why you are suffering persecution. And of course, with climate migrants, it is not for any of those reasons. It is simply for the reason that you are in a particular location. It can, of course, you can be particularly affected as coming from a particular ethnic background because of a particular region, but in general, you are not persecuted for that reason. I think the reason why us asylum lawyers don't necessarily engage with climate migrants as a topic, as an issue, is because a lot of those climate migrants, 3 times as many apparently as other migrants, other refugees, also fall under the convention. And that's one very good example, as Krishnendu mentioned, is Darfur, where it is the limited resources that lead to a conflict that then breaks down on ethnic lines, and then suddenly those very refugees who initially would have been climate refugees are now also convention refugees, or climate migrants are now also convention refugees. And so for that reason, I think it's interesting that I have never engaged with making a climate argument in an asylum claim, and speaking to my colleagues, they have not either, because we can often rely on the convention grounds, and we don't need to make that argument. So that's just the first point to note that, I mean, there might be utility in us starting to raise those arguments and starting to introduce that language. But at the same time, because the convention doesn't offer protection under that ground anyway, there's limited use to it, and you don't want to weaken an asylum claim by confusing it, by adding a limb that actually doesn't offer protection. But then, so that's basically the Refugee Convention. So that moving to the 2 possible other routes, I think basically we're then looking at the unlucky migrants, refugees who do not also fall under the convention, and those somehow need to find protection. And what do we do for them? And we would then look at either the options of humanitarian protection and what that offers. Humanitarian protection is a kind of subsidiary protection within the UK. I'm not sure exactly what my audience is here, how many of you are asylum lawyers, and I'm boring you to death, but I will just quickly introduce it anyway. It's a subsidiary protection through EU law. And it is something that the Home Office must consider. So if you refuse refugee status to someone for example, because they were not persecuted on one of these convention grounds, then the Home Office must consider whether to still grant humanitarian protection. And what that is a lesser status of protection. You get fewer years. You used to get 5 years as well, but since the Nationality and Borders Act came in June last year, you'll now only get 2.5 years. So there's direct potential discrimination. I actually think that's an interesting point to raise the potential challenge is the discrimination of them being a climate migrant and therefore not being treated the same as a refugee, convention refugee. But looking specifically at what humanitarian protection offers, or how to establish humanitarian protection rather, you could look at, so you must establish a real risk of harm, death penalty or execution, unlawful killing, torture, inhuman and degrading treatment, or indiscriminate violence. And for our purposes, we'd focus on inhuman and degrading treatment. The Home Office guidance specifically states that there may be exceptional situations where conditions in the country, for example, absence of water, food, or basic shelter, are unacceptable to the point that return itself would constitute inhuman and degrading treatment for the individual. And that's really important. That seems to suggest that the conditions on the ground, regardless of your specific conditions, regardless of whether you meet a specific convention reason, the specifics on the ground, particularly regarding limited resources, could give rise to a grant of humanitarian protection. I think that can be used for climate migrants. There is also unhelpful case law, which again would be interesting if we could develop it, but there is unhelpful case law regarding medical cases. There's this whole trajectory of what is inhuman and degrading treatment and when is the state in breach of it if they were to remove someone to their home country. And a new set of case law developed in the 90s regarding medical cases specifically. And so somehow we treat these medical cases differently under Article 3. Usually we talk about torture by the state. That's a really clear Article 3 claim, and you can't remove someone as they're going to face torture in their home country. But then we introduced, or the European Court of Human Rights introduced this argument that actually on medical grounds, if you would suffer inhuman and degrading treatment because you're receiving certain kind of medical attention in the UK, for example, you cannot be removed to the country, your home country, where you wouldn't receive the same medical treatment, and you would therefore suffer inhuman and degrading treatment and potentially even die more quickly than you would in the host country. So we have to keep that new set, which obviously isn't directly related to climate cases, but it is very useful to us to develop a climate argument because it's also about the conditions on the ground in the home country. And it expands the meaning of Article 3 in torture and inhuman and degrading treatment. But we have to keep that in our minds. And specifically in relation to humanitarian protection, this is limited by CJU, so Court of Justice of the European Union case law, in the case of Harj and Kingdom of Belgium, where it says that subsidiary protection, which is a kind of humanitarian protection, requires that the harm from which the claimant seeks protection must emanate from the conduct of a third party, and therefore cannot simply be the result of a naturally occurring illness combined with general shortcomings in the health system. So that suggests that if there is a naturally occurring illness and the home state can't protect, then you cannot rely on it as a ground of humanitarian protection. Now, I think we can interestingly distinguish that case for climate migration because it isn't naturally occurring, it is man-made, but it still would be the home state not being able to sufficiently provide the protections and shortcomings against that threat. So it would be an interesting case to develop humanitarian protection and bring that and bring climate migration as part of that within its realm. But again, to note, this is still less favorable. It is still only 2.5 years and not 5 years, not the same protection you would get as a refugee. And that in itself may be a ground for discrimination. If we focus on the kind of harm that you suffer rather than the kind of status you obtain, maybe there is a way to say that climate migrants and refugees should be treated the same and therefore be granted the same kind of protection, and it would be discrimination not to do so. All right, now, if you fail on humanitarian protection grounds and still would like to, I'm actually running a little bit short on time, aren't I? So basically there is another set of challenges you can bring to try and get discretionary leave using the Human Rights Act, and again relying on Article 3. I'll skip the background, but importantly, in a recent case of AM Zimbabwe Supreme Court decision 2020, the Supreme Court upheld previous case law from the European Court of Human Rights, the case of Paposhvili in Belgium. And importantly, that establishes that although not at imminent risk of dying, if the person would face a real risk on account of an absence of appropriate treatment in the receiving country, of intense suffering or a significant reduction to life expectancy, then they can then removing them would be in breach of Article 3. Again, this is one of these medical cases, but significantly, it establishes that even if the risk is not imminent, you would still be able to rely on a potential breach of Article 3, of a forthcoming breach of Article 3. I think that's really important for climate cases, because often the threat will not be immediate. It will be, my country isn't currently underwater, it will be in 5 years. And it would be harder to frame an Article 3 challenge to say, well, currently, if I'm removed now, be subjected to inhuman and degrading treatment. But instead you would be in a few years. And if that is real, and if there's a real risk of that in a few years, it seems that we may be able to rely on AM Zimbabwe to expand that meaning of Article 3 and the protections offered under Article 3. And importantly, a more recent upper tribunal case upheld that those medical cases also fit material deprivation cases. So that means that we can actually immediately bring it into limited resources, lack of water, lack of, in the context of famine or droughts. So those are, I think, two areas in which if we accept that the Refugee Convention isn't fit for purpose, there are still two areas within UK law where we may be able to bring challenges and create, start to talk about climate migration and start to create protections specifically for climate migration, as we know that the number will only increase. So that's my note.
Thank you so much, Nina. It's really useful to get, I think, some kind of concrete avenues to explore, which I think helps situate, different ways for us to think about tackling these huge and sometimes kind of overwhelming issues. So thank you so much for that. So we have about 15 minutes, channel as many of the audience's questions to the panel as possible. So we have two at the moment. So if you have any questions, please feel free to put them in the Q&A box, and I'll direct them to the panelists. And if you have a specific question for a specific panelist, let us know. So the first one we have here is a question about essentially the way in which we can try and develop some degree of state responsibility around, as it's phrased here, environmental degradation and climate migration. And there are some suggestions around using international courts essentially, and an erga omnes obligation kind of framework to try and essentially pin responsibility on states. I might direct this one at Tublu and feel free to speak to any kind of relevant international climate litigation in this space. But what do you make of that as an avenue for us to think about? Is it one that international courts are going to be kind of willing to explore, or should we be focusing maybe on more available domestic options, maybe in the vein that Nina was discussing?
I think, and I keep saying this, I think in all the meetings on climate that I attend, that no option should be ruled out, and that it should be all options at any time, everywhere, because of the nature of what we're facing and the need to, the urgency. I mean, in terms of international law and international courts, I mean, there has, and you probably know better than me, Harj, there have been rulings under the special procedures of the UN which recognize, in the context of the right to life, situations where people have been displaced from Kiribati Island to New Zealand, I think. But I suspect, as with what Nina talked about, the medical cases and the material deprivation cases, that the circumstances, the thresholds will have to be very, very high, and also would probably relate to situations. Obviously, the concept of internal flight, can you relocate somewhere else in your home country, as applies in the Refugee Convention, also would apply in relation to climate. And so, you know, I suspect that when you're looking at migration and protections of people who migrate because of climate, that the thresholds which are already in existence in terms of the 51 Convention will be replicated, and probably because of the numbers of people that potentially will move or can move, will necessarily be higher.
Great, thank you. So we have a second question here, which is about essentially the extent to which climate change can be said to cause migration. And I think I'll address this one because it's an issue that we see in the climate litigation field, which is essentially this question of causation or attribution. So the science on this point is one that has rapidly developed in the last few years. So there's a field called attribution science, which is essentially trying to attribute discrete extreme weather events to the emitting activities of a particular emitter, or to climate change in general, which can then obviously be tied to a particular emitter's historical contributions to climate change. And so the state of the science now is that climate scientists, attribution scientists, are able to, after an extreme weather event has taken place, within a matter of a few weeks, determine whether and the extent to which it is created by anthropogenic climate change. And so we have, in some ways, cleared one of the key scientific hurdles to establishing causation. And so there are a number of cases to international or transboundary cases. One is the Liu case, which is a case looking at the threat to a Peruvian individual through a glacial lake, which has expanded due to glacial retreat. And a case has been brought against RWE, which is a German electricity retailer, for their historical contributions to climate change, contributing to the increased risk of a dam collapse. And that is predicated fundamentally on attribution science, saying that they can be linked to that climate change. So that similar logic can be applied, I think, in the climate migration context, where you can say that climate change is anthropogenic, and then can be drawn to specific extreme weather events that might displace people internally and across borders. Yeah. Krishnendu, if you want to come in.
Yes, if I could just come in on that. I mean, yeah, I mean, it is a difficult task. I mean, for instance, in the Sundarbans, we've had maybe 15 or even 20 years of science which says that the delta area of the Sundarbans is affected by sea level rise and increasing cyclonic activity and saline intrusion and so on. But those are not the only factors which are causing problems with livelihood and people to move. There's also commercialization, corporatization. So what was if you like a sort of artisan farming or an artisan fishing, now we're seeing sort of large commercial trawlers which are affecting the traditional livelihoods of the people who've been there, plus an influx of population from other parts of South Asia. So all of these are stressors which are leading to livelihood problems, which then ultimately can force people to migrate. And so sort of saying that something is largely caused by global warming is not always easy, I think.
Certainly, and I think that's why some of the cases that you see filed have very specific factual circumstances where solicitors and barristers are being very clever about the types of claimants they're picking, the types of circumstances, the types of extreme weather events that they're identifying, so that they're essentially trying to isolate out as many of those other variables that you're pointing to. But of course, it's an incredibly kind of complex issue to disambiguate, and that's a challenge for both solicitors and for courts. Yumna, you've got your hand up. Would you like to come in?
Yes, please. And I will cheekily merge my contribution with the question about the UN Special Rapporteur's thing about climate refugees that came out a few weeks ago. I would just reiterate that the social nuances that I spoke about earlier about who is most vulnerable to climate migration and the fact that it's been happening for a long time, it's not something that's going to happen, means that there are different factual scenarios, which you both touched on. And so I think that this sort of litigation that is solely based on, the factual matrix, did this climate event cause this movement? It's extremely useful, but I don't think that it's a one size fits all. Something that's really important to consider is that it's a widely held view that the root cause of the Syrian revolution and the Arab Spring was actually climate change. So drought led to famine, led to anger, and a wider notice of all of the other wider political issues and pressures and inequalities, and that sort of is seen as having driven the revolution. And what Nina touched on earlier is we don't necessarily have to refer to climate in order to provide protection to certain groups of people, but for other groups it will be a material factor in what drove the movement. And so I think that this sort of socio-economic nuance and lens is really important when we speak about climate migration, because it doesn't look the same in different places and for different groups. So I just wanted to provide some caution. And in terms of the UN Special Rapporteur's initiative, I think it's brilliant. I think it's a long-awaited action plan. It's good to see someone writing something about this. However, I, again, don't think that it will help everyone. As I mentioned, most movement relating to climate change is internal and within borders. And so the Refugee Convention, again, will not address this, nor will it serve to protect people. And I'm worried about the global community jumping on the bandwagon of the expansion of the Refugee Convention to include climate-related harms, and leaving behind millions of people who will not fit within that definition because they are unable or do not want to move further or cross a border. So that is my answer to both questions.
Thanks, Yumna. Nina, Krishnendu, I'm not sure if either of you wanted to come in on this question of the optional protocol. I think it's an interesting kind of strategic question of how do we channel our energies. There's a lot going on in the international space, both before international courts in relation to climate change, with 3, maybe 4 advisory opinions. Obviously, the proceedings for the European Court of Human Rights. There are pushes around different proposed international treaties. One of them is the Fossil Fuel Non-Proliferation Treaty, which is gathering a lot of steam. Is focusing on something like an optional protocol to the Refugee Convention to focus on climate migrants dividing our attention, or is it something that's necessary? I don't know if Krishnendu, you have thoughts, and then I can come to Nina.
Well, I mean, the thing about all international law, and in particular, I think the Refugee Convention, is that it's a living instrument, and it has to be fit for purpose. Otherwise, it defeats the object of being a signatory to it and incorporating it and so on. And then there's plenty of judgments that say that in terms of the 51 Convention, it should be seen in light of current situations, current pressures, conflicts, persecution, definitions of social group, as a way that society evolves. I don't see any particular reason why, if there is a proposal to have an optional protocol which then extends the definition, and obviously the definition of the Refugee Convention has also been extended by the Geneva Protocol, and so there's precedence for that. So there's absolutely no reason why it can't be extended again. Now, the problem is obviously that we're to get political buy-in on that is the difficult part of it, and that is something that only people can demand.
Great, thanks, Nina.
Yeah, I think especially considering the limitations of trying to work outside the Refugee Convention, I think the most important reason why we do need some kind of other instrument or protocol is the climate justice element of climate migrants who don't fit within the convention, or even ones who do fit within the convention. The attributing blame and therefore also taking responsibility for taking people in. The narrative changes quite a bit. I mean, we're currently faced with so much animosity towards migrants in this country, and I think the conversation really changes when we suddenly start to attribute blame to the UK for potentially causing that migration, and perhaps having a specific protocol could start to address that. And we can't quite address that if we just try and use the tools we already have, because we simply haven't considered protection in that way before.
Great, thanks, Nina. I think maybe just a final question to wrap up, and I'm keen for us to finish on time, is just this question of narrative. I think one of the interesting points that's emerged today amongst the panel is obviously Yumna's I think compelling arguments in favour of using the terminology of climate migrants, migration in place of climate refugees because of the legal and definitional problems with that term. But I wonder if we are foregoing something in terms of the narrative power, the social and political power of being able to communicate the concept of climate displacement through the label of a climate refugee, which has a social understanding in a more kind of abstract way, which is different, obviously, to a legal and technical definition. Maybe I'll come to Blue on this one. Do you think that there's utility, maybe strategic utility, in trying to use the terminology of climate refugee because people are familiar with what refugees are? They're people who are vulnerable, they're in need of protection, they're facing imminent threats, or should we try and be more precise with our language because of the need to have legal clarity?
I think I'll say two things about that. First of all, I think one of the reasons why we do have a degree of animosity towards 51 Convention refugees historically is a failure of imagination, and there has to be some way of getting people to understand what it's like to be persecuted, to be in a conflict, have to leave your home, and so on. And I think that applies as much with climate people who are forced to shift because of climate. There is a failure of imagination to understand the situation in which Geeta is living in the Sundarbans, that she has her land taken away from her and her family has to migrate. So I think there's arguments on both sides, but one of the things that we have to put across is that this is a humanitarian crisis as well as a crisis on a whole number of different levels. It involves humans, and that whatever language can be used to make sure that people see these people as humans, and especially those who don't have any real responsibility for the situation in which they find themselves, would be useful.
Wonderful. Thanks, Krishnendu. And I feel like that's a hopeful and universal note for us to land on. So thank you to the panelists, Nina, Yumna, and Krishnendu, for sharing your thoughts and expertise on this really fascinating topic. I'm sorry we couldn't get to all of the questions in the Q&A, but I appreciate the engagement and clear interest in this topic. So thank you, everyone, for attending. We'll be having more climate-related sessions throughout the year, both in person and online, hosted by the Climate and Environmental Justice Group. So keep your eyes peeled for that. But otherwise, thank you all again, and have a great day.
Thank you, everyone, and thanks